Hi, David.
Hey Beth, how you been?
Good. How are you?
I'm doing well. Thank you so much for having me back.
Oh, of course. So I'm Beth, and I'm a business coach at the Small Business Development Center at Lorain County Community College. And I'm joined today with David Vance from Vance Law. And David, your practice is really around employment law.
That's
So,
that's correct. I'm an OSBA, Ohio State Bar Association certified specialist in labor and employment law, and that's pretty much all I do.
okay. Yeah. And, it's always great to chat with you. And you bring so much knowledge to our clients, and things that we don't know that we should be thinking about, right, when we're growing our business and getting ready to hire. And our last Let's Chat, we talked about the W-2 versus independent contractor. And so after that, you and I continued to talk, and you mentioned something about wages and classified employees and overtime, and I was like, oh wow, like those are things that our clients probably need to know more about too. And it's hard to
Right.
know where to look for that information, right? Or maybe they're not sure, if they could ask an HR consultant or if they should work with a lawyer. So I'm glad we're having this conversation today. So yeah. Yeah. So what are some things, like the main laws addressing the payment of wages to employees? So when someone's thinking about, they're ready to pay somebody, what should they, those laws they should be considering?
So there's really two big ones. The main one, and the one that most employers need to be focused on, is the Fair Labor Standards Act, which is a federal law. It's also called the FLSA. And that addresses things like minimum wage. It sets the federal minimum wage, which is 7.25 right now. And then it also sets parameters around the payment of overtime and when overtime needs to be paid to employees, who can be paid a salary, who can be paid or who should be paid hourly, those types of things. Now, Ohio also has a law that's largely mirrors the federal Fair Labor Standards Act. Ohio also, though, does have a law called the semi-monthly payment of wages statute, which a lot of employers kind of miss. And that is a statute that requires employers to pay their employees at a minimum 2 times a month. Certain parameters. That's Ohio Revised Code 411315 is the actual statute. And it's something that, every now and again, I'll come across a small business or one of my employer clients that says, oh, we're only paying monthly. Like, no, you need to be paying at least twice a month. And there's certain parameters that are around how and when you've got to pay those employees.
Oh, okay. See, I already learned something. I did not know that. So yeah, okay. And it can be hard as a new as someone like, okay, I just hired an employee, and maybe you don't always have the money to pay monthly or semi-monthly. So that's
Right.
something obviously to really consider when thinking about hiring. So
100%,
yeah.
100%. Or sometimes maybe your clients haven't paid you. And now you're thinking to yourself, well, gosh, I've got payroll set up for 2 weeks, but I don't have the money to pay them. So I got to push it out for a month. Well, guess what? You just violated the law.
Yeah.
So you got to figure something else out.
Okay. Okay. So what are basics I should consider when paying employees?
So really one of the most important things, or probably the most important thing, is to make sure you're paying your employees for all the hours they work. So if the employee is there, they're working, they need to be paid, right? Especially your hourly employees. So one thing I see often is, an employee takes their lunch and the employer starts asking them questions during their lunch, or they're still answering their phone because they're the receptionist and they're technically on their lunch, but they're also working. They need to be paid for that time. Just because they're clocked out, if they're performing work and it's more than de minimis work, they need to be paid for it. Same type of deal when, an employer has a policy that says nobody's allowed to clock in before 7 a.m. And there's an employee that gets there consistently at 6:45, starts work at 6:45, but doesn't clock in until 7. The employer knows the employee is working at 6:45. They need to pay that employee beginning at 6:45. Now, if you want to discipline the employee for getting to work before they're supposed to and performing work before they're supposed to, that's fine, but you absolutely have to pay them for the time they're working, regardless of whether or not they're clocked in. So number one, make sure you're paying your employees for the hours they work. The second real big one is make sure you're properly paying overtime for all hours worked in excess of 40 hours in a work week, right? Now, people are always asking, well, what happens if they work more than 8 hours in a day? Do I have to pay overtime? What happens if they work, 4 10-hour shifts? Do I got to pay for hours 9 and 10 at overtime? No, not in Ohio, not under federal law. The only time you have to start paying overtime is when they work more than 40 hours in a work week. So that's the next big piece. The last big piece I would say is make sure you're properly classifying your employees as whether or not they're exempt under the FLSA or non-exempt under the FLSA. And that really speaks to whether or not you're going to pay them hourly or via salary.
Oh, and so that's something that as a small business lawyer, employment lawyer, you can help them with understanding if they should be exempt or non-exempt, or is there a place they can go to learn more about that?
So the Department of Labor has some really good resources, the
Okay.
US Department of Labor. And if you type in FLSA, I believe they even actually have a guide for employers.
Okay.
And I would always recommend that employers start there and use the resources that are available to them, because one, it doesn't cost anything. And two, even if you do eventually end up talking to an attorney, you'll be better educated and you'll understand what questions you need to ask and have just a better sense of what's going on if you do ultimately need to talk to an attorney. But I'd start there 100%. Just use the resources that are available to you.
Okay, great. And so I'm hiring people. Should they be hourly or salary? How do I know? We'll look at we'll go, oh, let's look at your numbers. Like, let's look at what you're earning, or your business expenses. But obviously it's more to that than just that. So.
Right. So the safest way is always hourly. So I would,
Okay.
as a small business, I would make that my default. Now you can certainly pay employees, a salary. And there are exemptions for that under the Fair Labor Standards Act. The exemptions range from, a management or executive exemption, which applies if the employee manages 2 or more full-time employees, or the equivalent of, 2 or more full-time employees. So say 4 part-time employees. But the management has to be more than just like, hey, making sure they're here, maybe issuing discipline every now and again. They kind of have to have the authority to fire, hire, and really or have their input given significant weight by the employer. So it's not just, hey, they manage employees, they can be exempt under the FLSA. That's not enough. There's also an administrative exemption, which if they, perform certain duties that relate to running the business, and they have significant discretion as to significant matters, and the authority and the ability to make important decisions for the company, then they might fall under that administrative exemption. There's also a professional exemption where if you've got like a certain training, college degree for certain specific things, then you fall under that. Or there's also like a artistic or creative professional, which falls, your more art related professions fall under that exemption. There's also a computer exemption for various different computer employees or IT type folks. The big thing though is that under all of these exemptions, at least, you have to be paying the employee at a minimum on a salary basis, which they're going to earn a set salary for, every 2 weeks, they're going to get X amount of dollars. Annually, that salary's got to be $35,568. That's the current number. So if you're looking to pay somebody a salary of $30,000, that's not going to cut it. And they're going to be deemed hourly, and you should be paying them hourly. So that's the threshold. It's $684 a week is what it really works out to be.
Okay.
Start there, and then you got to look and see, okay, do these employees fall under one of these exemptions? There's some other ones like outside sales and things like that, but those are really the big ones.
Okay. What are some common problems, like common wage and hour problems that you see?
So there's a lot. One of the biggest ones is misclassifying employees as exempt when they really shouldn't be. So, you say you've got an assistant manager and you're like, oh, okay, they're manager. So they can be a salaried employee, and then you don't pay them the $35,568. You only pay them $32,000, or maybe you pay them $50,000, but they only manage one employee. So they're not really exempt under the FLSA. So misclassification issues is huge. So any small employer, any employer really, if you're out there and you're looking to, put somebody on a salary, you need to be doing some sort of analysis as to whether or not that position is properly classified as non-exempt. And you can't just take the status quo or what's always been done. So many times I'll ask a business, why is this person classified as, salaried, or why are you paying them a salary? Because that's what we've always done, or they're making $75,000 or whatever it is, right?
Yeah.
You need to do a little bit of legwork, and it's well worth the time and the effort up front to make sure you're not misclassifying folks. So that's a really big one. There's a whole nother let's chat on this. You already alluded to it, but misclassifying individuals as independent contractors when they really should be employees. If you have questions about that, check out the previous let's chat we did. Miscalculating overtime is a real problem
Mhm.
that often comes up. Not paying for drive times, an issue that I see regularly.
That's so interesting. So what kind of employee, so drive time when they're hourly or,
So drive time when they're hourly, right?
yeah,
A good example would be like a landscaping business.
okay,
So you have all
yeah,
your employees come to the shop and they load up the vehicles and then they head out to the first job.
sure,
So the moment they get to the shop, they start performing work, they got to clock in, right? Or they're on
right.
the clock, so to speak, whether they actually punch a time clock or not. Now their drive time from their home to your business, to your landscaping business, that's not compensable. That's just typical, you're traveling to your job. Assuming, of course, that they're not performing any work at their house before they come to the job site or come to the shop. So the moment they leave the shop or the moment they get to the shop, they start loading up the truck, they start performing work, they're on the clock. So they
Yeah,
go to job one, right? They finish job one in a couple hours. Then they drive to job two. That time between job one and job two, that's compensable time. They need to be paid for that. And I've seen a lot of lawsuits where employers think, oh, well, they're just driving around, they're not working, and they take them off the clock. So drive
yeah,
time's a big one that you really got to be conscientious of and careful of. The other big issue that I see a lot of times is improper deductions, where employers are just taking it. So we gave them a t-shirt
mm,
as part of or we gave them uniforms.
mhm,
And the uniforms, maybe they're really expensive, maybe they're boots, like who knows what it is. And they deduct like $200. Well, you've got like an employee that's making $8 an hour. You now drop them under, at least under the federal set,
mhm.
Ohio now, keep in mind, Ohio's 1010 an hour for employers that are with gross receipts over $371,000. So say you've got an employee that's making 1050 an hour, and now you just took $200 away from their pay. You've
Mhm.
now dropped them below minimum wage, and you've created a wage and hour violation, and you're in violation of the law. So
This is so, I'm learning so much. So yes, thank
yeah,
you.
employers need to be really careful whenever they make
Yeah.
a non-tax, Social Security, your typical deductions. I mean, the best practice would be to pay the employee and then have the employee cut you a check
Mhm.
for whatever the uniform is and whatever it is. Like say they got a traffic ticket driving your vehicle and they got to pay for the traffic ticket, have the employee just cut the company a check or give you cash as compared to doing a wage deduction. But if you're gonna do a wage deduction, make sure you have a form that the employee signs and fills out. The company can fill it out, and then the employee signs like, yes, I authorize the company to deduct this amount of money for this purpose.
Okay.
It's just
Okay.
kind of one of those best practices. And then even if you have that form though, don't let it mess with the employee's overtime and don't let it drop the employee under minimum wage.
Mm.
Like you may have to just take out, $25 a pay if that employee's flirting with minimum wage.
Got it.
Different things you got to do.
Sure. And so you just mentioned, we've said overtime a few times. What should employers know about paying overtime?
So overtime, the first thing you got to know is you got to know what's your work week, right? Every employer should have in writing, and they should convey it to their employees what their work week is. A lot of employers will do say, starting at Sunday at 12:01 a.m. through the following Saturday at midnight, right? So that's
Mhm.
their work week. And then what they need to know is any hours, if you're an hourly employee or non-exempt, anytime that employee works more than 40 hours, they need to be paid a time and a half.
Okay.
Okay. Now, this is actually just their work time. So if an employee, say, works 32 hours or call it, say they work 30 hours and they take 2 days of vacation for an additional 16 hours. So really, they're going to get paid for 48 hours.
Mhm.
Those 2 days of vacation, that doesn't count for purposes of overtime. So you don't have to pay 8 hours of overtime. They only worked 32 hours. Okay.
Right. Okay. Got it.
That's
Right. Okay.
certainly something you want to keep in mind. You want to make sure not just PTO, but holidays. So it's the July 4th weekend. The employee worked again, call it 40 hours exactly, but then they also had the holiday. So they got another 8 hours of holiday pay. That's not time they worked. So they don't need
Oh,
to
right.
be overtime in that instance.
Right. Right.
Um, you really got to be mindful of bonuses, commissions, shift differentials, those types of things, and how they then get calculated into the overtime rate. A lot of times what employers do is say an employee makes $20 an hour and they're an hourly employee and they get, they work their call it 45 hours. So they're supposed to get 5 hours of overtime at
Mhm.
time and a half. So it's $30 an hour, 20 times time and a half, $30 an hour for those 5 hours. Well, if that employee also worked third shift and they got like a quarter for work, like a shift differential, a quarter for working that, third shift, and that quarter's got to be figured in. It's not just time and a half at 20, or if they got a bonus that was non-discretionary, like an attendance bonus for showing up every day of the month, and they had overtime that month, you got to go back and figure out, okay, how much overtime should we have paid based on that bonus, or commissions potentially. There's a lot of things that can kind of go into what they call the regular rate that
Sure.
employers need to be mindful of.
Sure. Okay. So, and just I'm going to throw this question there. So 40 hours is obviously a regular work week. If anyone's under 40, is that or a full-time job? If you're under 40, is that considered part-time, or is it like 32 hours? Like, is there a difference, or doesn't it matter?
It doesn't really matter. I mean, there are a few places where it does matter for like the Affordable Care Act and different things like that, where it makes a difference as to what, the threshold is. But for purposes of overtime, it's 40 or nothing.
Okay. Okay. All right. So we had just mentioned drive time as one of those things that employers sometimes, don't pay for when they should. But what are some other concerns with drive time?
So, I mean, really the biggest issue is that going between jobs. I think the employer misses and it doesn't pay them for going between jobs, or maybe there's like a really far job, or they're letting their employer or their employee take their truck home in the evenings, and then the employee's getting home and they're doing work to the truck, servicing the truck. Well, guess what? Now that drive time from the last job of the day to their house, that's compensable because the employee got home and they did work on the truck. They loaded up, maybe they have materials at their house. So you got to be very conscientious. If you're a small business out there and you're listening to this and you let your employees take your trucks home, you want to make sure you're doing this right. Or if you have employees that drive and they stay overnight for jobs or things like that, there are a lot of different, drive time issues that they need to be aware of, cognizant of.
So what happens? So that doesn't, though, like if someone has a company car, so you like after work, you drive because you have a meeting an hour and a half away, you have to be paid for that drive time for that meeting, like maybe? Or
Probably. Yeah, more times than not. Now, keep in mind, this is hourly employees only. I mean, if it's an employee, they're just getting their salary and it doesn't make, doesn't make a difference.
Yeah. So what happens if this, the employer kind of screws up on this or makes a mistake or something like that? What are some of the fines or issues that could come from that?
So unfortunately, wage and hour issues are some of the worst problems that employers can run into, because the FLSA is so strict in terms of what the damages are. The damages are significant. So first, you're going to have to pay whatever you failed to pay. So if you miscalculated overtime, you got to pay what you should have paid originally, right? Or if you didn't pay minimum wage, you got to pay that. Or if you had somebody misclassified as exempt and they should have been hourly and you didn't pay them properly. So whatever you didn't pay that you should have paid, you got to pay that. That's the start. Then there's liquidated damages, which is basically whatever you should have paid, you didn't pay, you double it. So you got to pay that too. Then you got to pay the other side's attorney's fees if they retained an attorney. So if your employees hired an attorney, you got to pay their attorney's fees. You got to pay for an attorney to represent you. And there's also individual liability. So the business owner themselves, under the FLSA, they can be individually liable. So it goes beyond just the, what your company can afford to pay. It also involves what you can afford to pay. And when I first started doing this, 15 years ago, there were only a handful of attorneys that really took wage and hour cases on the employee side. There are so many out there right now, and this is such a hot button issue because they can get their attorney's fees. It's like it's mandatory. So in a lot of statutes and a lot of employment laws don't have that. So the damages and the penalties, I mean, separately, now that's all if the employee brings an action directly with their own attorney. The Department of Labor can come after you too, and they can levy fines and they can recover for the employees too. Frankly, sometimes that's better. It's not ideal, but it can be better. And even employers will sometimes self-report issues if they have a concern, so they can reach a resolution.
Yeah. I'm just like my head's spinning. I'm like, wow. Yeah. So this is a question we get a lot. Should you use a payroll company or try to enter payroll yourself through, your accounting software or something and you know, figure out those employment taxes on your own? I know what my answer is. Like, yeah.
So it's a really good question. A lot depends on, how good is your accountant? How
Yeah,
much do you trust your accountant? If you've got a great accountant and they're a good resource and they've been able to help other people with this, then maybe that, lends itself to trying to do it yourself. You get too big too fast though. Like I'm a big proponent of retaining a third party to handle your payroll because they're going to know a lot of the things that you don't know. They're going to know you have to pay semi-monthly.
right.
They're going to know potentially how overtime's got to be done. They're going to know like Ohio on your wage and hour time, on your pay stubs, there's certain things that have to be on there. And you may not know all those things, right? And then you're just issuing checks to your employees and it doesn't say, okay, well, when did they work? What's their hourly rate? What's their address? All these things that should be on their pay stub that aren't on there. And those are technically violations of the law. So I'm a proponent and they're pretty cheap at the end of the day to
Right.
do it. So you're probably best suited to do that. Now just keep in mind though, I just had a client just within the last couple of weeks come to my office that was using a third-party payroll company that wasn't paying semi-monthly.
Hmm.
And that client had to address that issue. And that was a big issue. And the payroll company should have caught that.
Sure. Yeah,
So,
no, so doing some vetting, but there are certain things that we're all about paying for and building into that. And
absolutely right.
having a lawyer, having payroll company, bookkeeping, certain things that just are so much better, and it won't cost you, will save you money in the end, actually.
Correct.
Yeah.
100%.
Yeah.
Right.
So what are some final thoughts that businesses should use to avoid or that you have about avoiding potential wage and hour issues, or anything else about hiring, paying employees that you want to share?
So a big one from my perspective is have a mechanism by which your employees can raise a concern about their pay if they have an issue, right? So if you're a small business and maybe you have an employee handbook, maybe you don't. I mean, you should have an employee handbook, but at a minimum, there are certain things that you need to share with your employees so that they know they can raise concerns. One of the big ones is if they have a wage and hour issue, or they think their pay was shorted, or they worked X amount of hours and they didn't get paid for it, or whatever, there's got to be somebody within the organization that they can report these things to. But more than that, don't just have somebody they can report them to. Like you actually need to take action, right? Like you have to follow up and you need to do so timely so you're not violating some of these laws related to, overtime, semi-monthly payment of wages. I mean, that's the really big one. And then I would just say be proactive. I mean, the damages and the liability here are so significant that you need to look at this stuff and you can't just whimsically say, oh, salaried employee, this is how we're going to do this. Yeah. We gave them a management title, so they're a manager. It doesn't matter.
Right.
They don't, supervise anybody. They're a manager, so we can pay them a salary. Don't do that stuff. Go to the Department of Labor's website, pull their FLSA employer's guide, read it. Mm-hmm. Because again, the liability, the potential damages here are significant. It could bankrupt a small business, frankly, if you do this wrong.
No, this is so important to share with everyone because, small business owners, we are often bootstrapping everything and just figuring it out as we go. And you definitely need to do your homework and absolutely on this topic and other issues around hiring employees as well. And definitely a handbook is a must. So we can definitely refer you to someone who can write a handbook, and we can help you get started in one as well. But absolutely have to have that. But so thank you so much for chatting with me today about wages and paying employees. And this was very eye-opening. And we always appreciate your insight and sharing your expertise with our clients. So thank you.
You're welcome. And thank you for having me. I always appreciate the opportunity to be here. You are doing a great thing over there at the SBDC, and anytime I can be of assistance, please don't hesitate to ask. So thank you.
Thank you. Talk to you soon.
All right. Take care.